fundamental duties, especially after that scintillating pre-lunch session. The concluding and
Yeah, just
rather
facing
all-encompassing
the
fundamental
voice
duty
issue.
enlisted in our strive for excellence, perhaps to the all-abiding legacy of Honorable was this expression that is the commonality among our each of our panelists have embodied in themselves the unending quest to strive for excellence. Our panelists are Honorable Justice Pardiwala, Judge
सर आप वीडियो स्टार्ट करो तो वो आपको टेक्स्ट करेंगे कि
I
चल रहे हैं
understood.
It's working. हाँ, so now you can start again.
A very warm good afternoon to one and all. I think it's a little difficult not to continue on fundamental rights and fundamental duties, especially after that pre-lunch session, which was scintillating. The concluding and rather all-encompassing among fundamental duties enlisted in Article 51A titles as the duty to strive for excellence. This duty perhaps that draws us all to the all-abiding legacy of Honorable Justice H.R. Khanna. Of course, this expression that is the commonality among our panelists today. Each of our panelists have embodied in themselves the unending quest to strive for excellence. Our panelists are Honorable Justice Pardiwala, Judge, Supreme Court of India, Nidesh Gupta, sir, Senior Advocate, Supreme Court of India, Siddharth Bhatnagar, sir, Senior Advocate, Supreme Court of India, Professor Ved Kumari, Vice Chancellor, National Law University, Odisha, Abhigalp Pratap Singh, Advocate on Record, Supreme Court of India, and Tariq Khan, who's shown the willingness to be here. To begin with, Honorable Justice Jamshed Burjur Pardiwala's family's tryst with law has a history predating the history of independent India and the Constitution of India by more than 50 years. His great-grandfather Navroji Bikaji Pardiwala started practice of law in the year 1894 in Valsad, located in present-day Gujarat. His grandfather and father all practiced law in the same court. Justice Pardiwala himself year. After dealing with cases of all kinds, astute mastery of all kinds with astute mastery, as we can all imagine, he was elevated to the bench in the year 2011. Through his more than 1,000 reported judgments in the field of taxation, constitution, commercial, matrimonial, and criminal law, to name a few, is a difficult task. His lordships disregarded the practice of customary divorce as non-commensurate with the constitutional ethos of today. He held that the two-finger test is unconstitutional and is an invasion of privacy. Well ahead of his times, his lordships observed that marital rape exists and is an offense. He observes that it is disgraceful and has scarred the trust and confidence of marriage. While the aforementioned judgment speaks volumes about His Lordship's passion for scholarship in constitutional law and law in general, we get to see a glimpse of His Lordship's compassion in COVID-related judgments and orders. An absolute honor and a rare opportunity for all of us to listen to Justice Pardiwala today. Nidesh Gupta, sir, our next panelist. It's often on a lighter note quipped by members of the bar and the corridors that Sir poses a challenge to the airline industry once in a while by appearing in more than 2 high courts a day. However, Sir's records and achievements do not start or end with this. Sir's father, Jawaharlal Gupta, had retired as the Chief Justice of Kerala. We could understand from our research that Sir has not only topped in his commerce honors in law, but also that his marks are still unbroken records in Punjab University where he graduated. Much before moot courts were in vogue, Sir has won the Inter-University National Moot Court competition way back in the year 1990. He enrolls in the year 1992, and over the years, we have seen him appear in the Supreme Court, almost all high courts, tribunals, Fortune 500 companies, chief ministers, bureaucrats, educational institutions. In the latter sphere, Sir has made it almost his forte. Some of the Fortune 500 companies Sir has appeared for would make an interesting list. From Mercedes-Benz to Castrol, from Samsung to Daikin, Paints to Nike, from Tata to Dabur, and from Motorola to Gillette. In the midst of all this, Sir has found the time to read scriptures of all main religions. And he has also shown heart to help many charitable institutions, including, but not limited to, our foundation, all of which is done in a most dignified way. I can only say that we are proud to have you here with us. Siddharth Bhatnagar, sir, our next panelist. Siddharth, sir, has always been a guiding light for all of us, not only members of the Khan Foundation, but all the younger members of the bar, for whom he's not only been a mentor, he is the mentor for us. Sir has graduated from the University of Cambridge in the year 1996. He appears in the Supreme Court, the High Courts, NCLAT, NCDRC, and NGT, to name a few. Before a constitution bench, he appeared in the case challenging Maratha reservation, as it's popularly known. He appeared for National Broadcasting Federation in the matter relating to media trials. He appeared for various minority educational institutions in matters relating to religious freedom, freedom of speech and expression, and apart from appearing in international commercial arbitrations regularly. We, on behalf of Khan Foundation, are deeply indebted for Sir's grace to be present here. Professor Ved Kumari is our next panelist. Apart from being the Vice Chancellor of the National Law University, Odisha, Madam was the Dean and Head of Faculty of Law, University of Delhi. She began her teaching career in the year 1983. She's written various books and innumerable articles. She's taught graduate and undergraduate students and has guided PhD students for their theses. Absolute pleasure to have you with us, ma'am. Abhigal Pratap Singh is a member of the Khan Foundation and is one among us. He's an advocate on record practicing in Supreme Court of India. He is an alumnus of Dr. Ram Manohar Lohiya National Law University. He's practiced in prestigious chambers like the chambers of Gaurav Agarwal and Dr. Shekhar Nafkat, senior advocate. We have Tariq Khan, sir, with us. Tariq Khan is currently working as the registrar of the International Arbitration and Mediation Center, Hyderabad. He's a former partner of Advani Law, New Delhi. He's also a professor at Nalsar University of Law. He's authored several books, including a commentary on Indian arbitration law. On behalf of Khan Foundation, I can only thank you for sparing your time for this webinar, sir. Before we start with our symposium, in memory of the all-abiding legacy of Honorable Justice H.R. Khanna, I would request everyone to stand in silence for a minute. I would request Professor Ved Kumari to deliver the introductory address.
Good afternoon to everyone present. My heartiest welcome to Honorable Mr. Justice J.B. Pardiwala, the other speakers in this session and the other panelists, as well as all the attendees. Justice H.R. Khanna is known for his dissent, and I think it is important in law to have voices of dissent. And I'm going to kind of speak a little bit on the dissenting note on the topic itself. There are two legs to the topic for this part of the symposium. The first part is listed as Vox Populi versus rule of law. There's a colon with the Supreme Court of India. Because we have got all the stalwarts from Supreme Court of India, from both the sides, from the bench and the bar. I'm not going to touch that aspect. But I do want to focus on the first part, which is Vox Populi versus rule of law. My understanding of the topic is that it is actually Vox Populi as the rule of law. There's no versus in the two. When we talk about rule of law, we are remembering our LLB days and IC, who gave us three basic principles of rule of law: equality, liberty, justice. Equality, nobody should have any special rights, everybody is treated equally. There should be no discrimination on the basis of sex, caste, blah, blah, blah. And then justice, that nobody is punished without proper procedures, and there is justice to all. And I think as women in our legal system and in society, we do not have anything to do with rule of law. Rule of law is about, it says equality, but then who is equal and how did this whole concept of rule of law came about? And we had this major theory of the social contract, and theory of justice by Rawls also talks about the social contract. Who are the parties to the social contract which created the legal system in which rule of law should be observed? These were certainly not women. These were propertied, able-bodied men. Slaves were not part of the social contract. Women and children were not part of the social contract. And even in Rawls' theory of justice, the people who were to do the social contract were supposed to be, give me a second, when he says it is free, equal, and independent human beings. So what we were talking about earlier, about social, about duties, fundamental duties, in the concept of justice by Rawls and this social contract theory, there's nothing about care. It is about being free, equal, and independent. Independence, to me, when we say independent human beings, then we're talking about my rights versus the others. When we talk about care, there's no independence, there's connectedness with the other. And women's perception of law is that it should be connecting people to one another, and that's where the fundamental duties fit in. Fundamental duties are about my duty to take care of the other, to think about the other, to promote the other. Fundamental rights say, I should have my own sphere to the exclusion of others. The moment somebody else comes in my life or in my space, my right is curtailed. But we constantly keep on talking about these as being just and proper and equality and liberty. Even till date, we do know that women are not recognized even by law. Forget about the Vox Populi. The law says women cannot be guardians. Mothers cannot be, they are not the natural guardians along with the fathers. Social belief is also the same. The popular belief is also that women are not the same. Mother can be euthanized, but she cannot be given rights. She cannot be given property. She is to be worshipped, but not given legal rights. We are moving towards equality in the law arena, but not in the social. And lots of judgments, lot of laws keep on reinforcing the same exclusion of women and the disabled and all this categories of people who are not free, equal, and independent. So I think somewhere the rule of law at this point of time, as conceived and as implemented, actually represents the Vox Populi. It is the public's viewpoint which are actually found reflected in the law. And certainly there has been stalwart judges and judicial decisions and lawyers who have worked to challenge that. But it hasn't happened that actually there is a versus category as of now between the two. When John Rawls talked about the two principles he had, there should be people who are, each person should have equal rights to most extensive basic liberty compatible with the liberty for others. Women till now are not, I mean, we're still talking about can they enter the temple, they cannot enter the temple, can they do this, can they not do this? And the most important for me has been the exclusion of personal law from the fundamental rights chapter 3. The moment in 1965, a judgment said that because personal law is not mentioned in Article 13, therefore personal law is not subject to equality. I think we did not talk about rule of law. We did not talk about justice for all. We did not talk about women being part of the legal system. Martha Nussbaum has given us a very nice critique of the way the Rawls theory of justice operates. When it says that when we talk about people who are free, equal, and independent, then certainly the people with disability are not part of that legal system. They're not part of the rule of law, because the rule of law, I mean, disabled persons with any kind of infirmity, whether that may be because of age, children, whether it is in case of persons with having impairment in their body and mind, or whether it is because of age in the case of older people as well. The system recognizes that they should be independent for them to be part of the decision-making process, which will ensure equality and liberty. Because I think there's a lot of things to think about, that how the patriarchal notions in the law have been incorporated in the legal theory, and again, vice versa in the law itself. Look at today's panelists. I happen to be a vice chancellor, therefore I'm here on the panel, the only sole woman in this whole panel since morning. We do not even notice who are the people who are being invited. Are there no women out of 8 speakers for the day which could have been part of this conversation? I'm also not supposed to be a panelist. I'm just there as an ex officio vice chancellor welcoming everybody. So we do not want to hear the voices of others. We choose people to head institutions to do things from what we consider as rule of law. But how patriarchal the rule of law is, we don't question that. And we don't do that in our law schools. So certainly I'm not blaming anybody. It is us, people like us in the universities, who have to open minds to start looking at critically as to what we've taken for granted, which has actually been the patriarchal philosophies. With that, I'll close my introductory remarks, because I was happy that I was asked to give introductory remarks and not welcome remarks. So I'm using that opportunity to introduce my thoughts on the subject. And I'm quite sure that there will be some more conversations happening. And I certainly invite, I'm very happy that CAN is doing what it is doing. And it's a very, very remarkable work that they're doing, supporting the young students and the young lawyers and anybody who is in need of family support. And with the kind of money they have generated, it is really remarkable. But I certainly would advise them to have a little bit more thought about diversity in your organization. It cannot be a Hindu male society. It has to have more diverse. And I was looking at even the Thanksgiving, even though in the previous session, a woman did give a bit of thanks, she was not listed on the speaker. Even in the thanks category, she was not listed. So within the organization structure, I did see there are symbolical women are there, but aren't they really participatory and in decision-making positions? We have to start from that itself to start thinking of rule of law, which actually signifies equality, liberty, and justice for all. All cannot be just men. Thank you.
Thank you, ma'am. We would take the word of advice with absolute humility, and we shall strive to see to it that these issues are addressed the next time we see a webinar and symposium in which you are there. Also, I would request a few minutes of everyone to see the PowerPoint presentation, which enlists the achievements and the endeavors of CAN Foundation. Please.
Good afternoon, everyone. Let me just take up a few minutes to shed some light on the topic for today's discussion, Vox Populi versus rule of law. From the perspective of Honorable Supreme Court, Vox Populi, Vox Dei, Latin for voice of the people, is the voice of the God, is a deep-rooted belief supporting the majority sentiment, the wish of the masses. On the other hand, rule of law is derived from a French phrase referring to a government based on principles of law and not of men. In a strong democracy such as India, it is incumbent on courts to take decisions concerning complex social issues and not dribble past them, as that is the mandate of the Constitution. In such a scenario, there can very well be instances when these two, Vox Populi and the rule of law, correspond with each other. But there can also be occasions when these two might be antithetical. The question of importance becomes, on which end does the constitution of the judiciary lie? We do understand that the court must uphold the constitutional principles, but the predicament that naturally follows is, can the judiciary choose to completely ignore the opinions of the public, especially when they are contrary to the law at hand? Let us get a perspective over here about the conflict between Vox Populi and the rule of law. The US Supreme Court, by its majority opinion, recently voted to overturn Roe versus Wade, terming it wrong from the inception and its reasoning exceptionally weak. Evidently, the ruling is at odds with the broad public opinion. In today's politically charged atmosphere, how far can the demands of the society remain unmet by the judiciary? Then again, in a contrasting situation of Delhi High Court's marital rape judgment, while the upholders of Section 375 insisted on the distinction between being founded on intelligible differentia, having a rational nexus to the object sought, the other side, amongst other things, pressed upon the need to take into account changing social and societal perception. In the light of this conundrum, I say there is always a looming concern that are people truly sovereign if the voices are not echoed by the judiciary. At the same time, can judiciary afford to be swayed away by majoritarian morals? Justice Cardozo rightly said that the judges do not live in ivory towers. It is an inescapable fact that the public has a direct influence on the court because the judges are concerned about their legitimacy and relevance in the short and long terms. But let's not also forget that there was much wisdom in Dr. Ambedkar's words when he warned us about not diffusing constitutional morality with public morality. The courts have been lately exploring the doctrine of constitutional morality with such refreshing interpretations, be it the historical Naj Foundation judgment or the reasoning behind striking down the second exception of Section 375 IPC in Independent Thought versus Union of India case. Nonetheless, the dilemma to choose between Vox Populi and the rule of law is a serious one, which the judicial institutions across the world have been trying to decipher for quite some time now. I must say that the Honorable Supreme Court has had its own fair share of difficulties in dealing with this impasse over the course of several judicial pronouncements, something which today's panelists will delve into in great detail. Thank you. I welcome the panelists to lead the discussion. I request Honorable Justice Paradiwala to initiate the question.
My respectful greetings to Professor Subir Bhatnagar, Vice Chancellor of Dr. Ram Manohar Lohia National Law University, Dr. Ved Kumari, Vice Chancellor of the National Law University, Odisha, Mr. Nidesh Gupta and Mr. Siddharth Bhatnagar, learned senior advocates, learned members of the foundation, audience in attendance, and my dear students. I consider it a great honor to participate as one of the speakers in the second Justice H.R. Khanna Memorial National Symposium organized to commemorate the colossal persona of late Justice H.R. Khanna. In the first session of the day, I had the pleasure and privilege to hear my esteemed brother, His Lordship Justice Vikram Nath, who spoke on the fundamental duties vis-a-vis fundamental rights under our Constitution. I have been requested to speak on the topics Vox Populi versus Rule of Law, Supreme Court of India. To pay tribute to late Justice H.R. Khanna, the former judge of the Supreme Court of India, by itself is a great honor bestowed upon me. Jean Monnet, father of the European Union, once said, I quote, "The world is divided into two types of people, those who want to be somebody and those who want to do something," I unquote. Justice H.R. Khanna is remembered and will always be remembered long after many Chief Justices of India are forgotten, because he did something for which he deserved to be remembered. Justice H.R. Khanna has been one of the greatest judges of the Supreme Court of India. His towering contribution to the judicial system of the country is immeasurable. A couple of months back, while I was a judge in the High Court of Gujarat, I, being an administrative judge of the Rajkot district, had to visit Rajkot. While I was in Rajkot, I was requested by the Rajkot District Bar Association to spare some time and address the members of the bar. I kept wondering on what subject I should address the members of the Rajkot District Bar Association. Ultimately, I decided to speak on the rule of law, least knowing that I would be talking on the rule of law as a Supreme Court judge in next few months. While addressing the members of the legal fraternity at Rajkot, I said that there are two basic roles of a judge. First, to uphold the Constitution and the rule of law. And secondly, to bridge the gap between the law and the society. In my address, I remember Justice Khanna, as I could not have explained what is rule of law in a better manner without quoting Justice Khanna. I made the members of the legal fraternity recall to their memory what Justice Khanna observed in the ADM Jabalpur's judgment. In the ADM Jabalpur's case, in his dissenting opinion, Justice Khanna observed, I quote, "What is at stake is the rule of law. The question is whether the law speaking through the authority of the court shall be absolutely silenced and rendered mute," I unquote. On Justice Khanna's resignation from the Supreme Court of India, the New York Times wrote an editorial titled, I quote, "Feeding Hope in India," I unquote, saying, I quote, "If India ever finds its way back to the freedom and democracy that were proud hallmarks of its first 18 years as an independent nation, someone will surely erect a monument of Justice H.R. Khanna of the Supreme Court." It was Justice Khanna who spoke out fearlessly and eloquently for freedom this week in dissenting from the court's decision upholding the right of Prime Minister Indira Gandhi's government to imprison political opponents at will and without court hearings. The submission of an independent judiciary to absolutist government is virtually the last step in the destruction of a democratic society, and the Indian Supreme Court's decision appears close to utter surrender. I unquote. Eminent jurist Mr. Nani Palkhiwala wrote an article in honor of Justice Khanna after his resignation in the Indian Express and stated that there were still judges in our midst who were true to the light within them and who remained unmoved, unshaken, unseduced, and unterrified. He quoted the following lines in that connection. I quote, God, give us men a time like this demands, strong minds, great hearts, true faith, and ready hands, men whom the lust of office does not kill, men who possess opinions and a will, men who have honor, men who will not lie, men who can stand before a demagogue and damn his treacherous flatteries without winking, tall man, sun-crowned, who live above the fog in public duty and in private thinking. I unquote. Justice Khanna belonged to that creed of men who, having donned the judicial mantle, maintained the highest standards in their judicial career. Ladies and gentlemen, I came to be elevated as the judge of the Supreme Court on 9th of May 2022. Supreme Court closed for the summer vacation from 20th of May 2022. However, for the entire last week, I had the honor to sit with a senior judge of the Supreme Court during the vacation. For the first time, I had the honor to sit in the court number 2 of the Supreme Court. I noticed that as a mark of respect, Justice Khanna's portrait has been displayed in the court number 2, where he used to sit and decide the cases. His portrait inspires the lawyers and the judges to follow his cherished values and principles. A Chief Justice of the New York State of Appeals, on his first appointment as a Chief Judge, proudly showed his wife the chair in the courtroom of his illustrious predecessor, or in office of nearly half a century ago, Chief Justice Benjamin Cardozo, a legend among judges of the United States. And he said to his wife in a reverential whisper, "See, this is Cardozo's chair, and this is where I will sit." His wife responded, not very reverentially, "Yes, and after 50 years and 5 more Chief Justices, it will still be Cardozo's chair." Ladies and gentlemen, the times would run through, and yet Justice H.R. Khanna would be remembered as Justice H.R. Khanna, with none who can surpass him. Let me now talk about on today's subject, Vox Populi versus rule of law. First, about the origin of the phrase, Vox Populi. Voice of the people is the voice of God, is mistakenly assumed as to how it originated. It is interesting to note that actually it was stated in a disapproving manner. The full quote is in a letter to Charlemagne or Charles the Great from Alcuin of York, an English scholar and clergyman in 798 AD. What Alcuin wrote, I quote, "And those who believe should not be listened to who keep saying, the voice of God, Vox Populi, Vox Dei, since the noisiness of the crowd is always very close to madness." The voice of the people is the voice of the God, was first used by the English Archbishop of Canterbury, Walter Reynolds, during a sermon in 1327 against King Edward II, who the Archbishop wanted removed from the throne, Reynolds was backing the wife, Queen Isabella, in her rebellion against King Edward II. Balancing the intent of the majority populace on one hand and meeting the demands of affirming the rule of law on the other is an arduous exercise. It requires extreme judicial craftsmanship to walk the tightrope between the two. What would people say? Log kya kahenge? Kya sochenge? Is an enigma which haunts each and every judge, every moment whenever he is to pen down a judgment having social ramifications. It is where the conviction, awareness of the constitutional values and conceptual understanding of rule of law of the concerned judge comes to the fore. When we use the term view of the public, it is not always synonymous with people in general or the head count of masses. I must say that the term is quite often misunderstood and misinterpreted. View of the people in the constitutional context implies a segment of society, a section of people that has some common shared interest sitting at the same table. It is often said that the rule of law is the most distinguishing feature of Indian democracy, which has begun its career under the Indian Constitution from the 26th of January 1950. Considered verbally and literally, this claim may sound to be unreasonable because even in countries which are not governed by a parliamentary form of democracy, rule of law in substance prevails. Even dictators have their laws and they are enforced, and in that sense, even the dictatorship can claim that it rules by law, and so the rule of law prevails in its country. That is why the claim that the rule of law is the most distinguishing feature of Indian democracy must be closely scrutinized at the outset. When we make the claim that the rule of law distinguishes Indian democracy, we have two significant factors in mind. The first factor is in relation to the mechanism of the making of Indian laws. The making of Indian laws is characterized by 3 Ds. Before a law is introduced in the legislative chamber, its merits are freely, fully, and fearlessly discussed in the press and on the public platform. When it is introduced in the legislative chamber, it is debated by the legislators who have been elected democratically on adult suffrage, and members of the opposition ruthlessly criticize it. And when it is passed, its validity is tested in the courts of law. Thus, public discussion, debate in the legislature, and the decree of the court are the 3 Ds which distinguish the mechanism of Indian lawmaking. And in this behalf, the Indian law differs from the law that is made by governments other than the parliamentary governments controlled by written constitution. When I refer to the decree of the court, it is necessary to explain how the courts come to have a decisive role, decisive voice in the determination of the question as to whether the laws are valid or not. A plea that a law passed by the British Parliament is invalid is inconceivable under the constitutional law in England, because the sovereignty of Parliament is literally absolute. The Indian legislatures, federal as well as state, are no doubt sovereign in their respective spheres, but their spheres have been specifically defined, and if they traverse beyond their prescribed spheres, the acts that they pass are liable to be challenged in the courts of law. The legislative incompetence is thus one basis on which the validity of laws can be challenged in India. The other basis on which the validity of laws can be challenged is in relation to the fundamental rights of the citizens guaranteed by the Indian Constitution. The Constitution has been framed on the basis that the individual citizens are entitled to certain fundamental rights, which are enshrined in its most important provisions. The Constitution has also provided that these fundamental rights can be regulated effectively by legislation, provided two tests are satisfied. The invasion or regulation of the fundamental rights must be reasonable, and it must be in the interest of the public good. Thus, a challenge to the validity of any legislative enactment can be made on the ground that the impugned legislation unreasonably impinges a citizen's fundamental right, or is otherwise not in the interest of public good, and these issues are justiciable in the courts of law. It is on the basis of these two grounds that the courts in India have been empowered to pronounce their verdict on the validity of legislative enactments. That is a very distinguishing feature of the laws that are made in India. It is from this point of view that we claim in India that the rule of law is the most distinguishing feature of Indian democracy. I firmly believe that there is no exception to it, that the rule of law must prevail, and public opinion hardly has to be subordinate. It has to be subordinate to the rule of law. In the words of Rose Bird, the former Chief Justice of the California Supreme Court, I quote, "The judiciary must not take on the coloration of whatever may be popular at the moment. We are the guardians of rights, and we have to tell people things they often do not like to hear," I unquote. I firmly believe that it is for the highest court of this country to decide any issue, keeping only one thing in mind, and that is the rule of law. The judicial verdicts cannot be the reflection of the influence of public opinion. However, I must not forget to make a mention of what the learned members of the Constituent Assembly discussed while deliberating on the content of the different articles of the Constitution. In the Constituent Assembly debate, dated 10th of December 1948, Professor K.T. Shah opined that the inclusion of Vox Populi in our Constitution was a necessity, as it signified that at the end of the day, the will of the people was supreme. He noted that there are those who were against people's sovereignty, in fact and in name, claiming that the people are not ready or that they are not educated enough to give any decisive opinion on such complicated issues of foreign or local policy, while graciously accepting the fact that the literacy among the people was less. They were all sincere and true, and in their belief that ultimately the people are sovereign. He said, I quote, where there is collective wisdom, there is after all real salvation. Vox Populi, the voice of the people is the voice of God. I unquote. It is very clear that he was of the view that the sentiments of the people must be given respect when it comes to judicial decision making. However, there is also a school of thought that goes against this belief. I belong to this school of thought. It emphasizes the need to disassociate oneself from the belief of the majority and go by the rule of law. The great thinker, John Stuart Mill, made a strong argument against popular morality being codified into laws. He stated that a popular distaste for an act or a thing cannot be classified as harmful or illegal only on the premise that it contradicts their beliefs or views. Hart expounded his warning about the imposition of majoritarian morals through the judicial opinions. He underscored, I quote, no one should think, even when popular morality is supported by an overwhelming majority or marked by widespread intolerance, indignation, and disgust, that loyalty to democratic principles requires him to admit that its imposition on a minority is justified, unquote. I believe that in a democracy, we have a systematic agreement to live by the court decisions. It does not mean that the court decisions are always right or free of all other considerations. We simply agree to live by them. In a democracy, knowledge is more important than the systematic and blind obedience to the popular verdicts, whether of the electorates or courts. It is true that while a judge's role is to uphold the law, the judge in an exceptional case may have to be cognizant of the sentiments of the society and the perennial effects of the judgment that he may utter. One of the earliest decisions during the nascent stages of our republic was the abolition of the jury system. The jury system's biggest criticism has always been that it flows with the majority will of the people and it adversely hurts the minority, while the trained judicial mind follows the letter of the law. The 14th Law Commission, apart from the other factors, also relied on the views of the father of the nation, Mahatma Gandhi. Gandhiji said that he was unconvinced of the advantages of the jury trials over those by judges. Thus, the trust on the judiciary over juries led to the abolition of the jury system. The finest example which can be cited in the modern times, wherein the Supreme Court upheld the rule of law versus majoritarian perceptions, is the Navtej Singh Johar's case, where section 377 of the Indian Penal Code was struck down to the extent it criminalizes consensual homosexual acts between adults. Honorable Justice Nariman, in his opinion, held, I quote, the very purpose of the Fundamental Rights chapter in the Constitution of India is to withdraw the subject of liberty and dignity of the individual and place such subject beyond the reach of majoritarian governments so that constitutional morality can be applied by this court to give effect to the rights, among others, of discrete and insular minorities. The Fundamental Rights chapter is like the North Star in the universe of constitutionalism. Constitutional morality always trumps any imposition of a particular view of social morality by shifting and different majoritarian regimes, I unquote. Honorable Justice Dr. D.Y. Chandrachud held, I quote, in the quest to assert their liberties, people criminalized by the operation of the provision challenge not only its existence, but also a gamut of beliefs that are strongly rooted in majoritarian standards of what is normal. In this quest, the attack on the validity of Section 377 is a challenge to a long history of societal discrimination and persecution of people based on their identities. They have been subjugated to a culture of silence and into leading their lives in closeted invisibility. There must come a time when the constitutional guarantee of equality and inclusion will end the decades of discrimination practiced based on a majoritarian impulse of ascribed gender roles. That time is now. Under our constitutional scheme, no minority group must suffer deprivation of a constitutional right because they do not adhere to the majoritarian way of life. By the application of Section 377 of the Indian Penal Code, MSM and transgender persons are excluded from access to health care due to societal stigma attached to their sexual identity. I unquote. No one could have put it in a better manner than Justice Dr. D.Y. Chandrachud. When we look at the landmark verdicts of the Supreme Court, like the ones in the cases of Sabrimala, LGBT rights, or those on death penalty, the friction between the aspirations of the society and the necessity of upholding the rule of law comes to the forefront. Let us recall to our memory the observations of the Supreme Court in Sabrimala's case. It's very important. I quote, "Let every person remember that the holy book is the Constitution of India, and it is with this book in hand that the citizens of India march together as a nation so that they may move forward in all spheres of human endeavor to achieve the great goals set out by this Magna Carta or Great Charter of India. Constitution is the will of the people, whereas the statutory laws are the creation of the legislators who are the elected representatives of the people. Where the will of the legislature declared in the statutes stand in opposition to that of the people declared in the Constitution, the will of the people must prevail. The Constitution of India provides for an elected president. House of the people is elected The state legislators are elected. The Supreme Court judges are not elected. They are appointed under the Constitution. So are the High Court judges. Yet the Constitution confers power called judicial review, under which the court may nullify the unconstitutional acts of the executive and of the elected representatives of the people assembled in the parliament and the state legislatures. This conclusion does not necessarily suppose that the judiciary is superior to the legislature. It only supposes that the power of the people embodied in the Constitution is superior to both. The role of the judiciary under the Constitution is a pious trust reposed by the people. Let me also talk about the role of media. A trial is essentially a process to be carried out by the courts. However, in the modern day context, trials by digital media are an undue interference in the process of justice dispensation, crossing that Lakshman Rekha many a times. This is especially all the more worrisome when those sections of people start scrutinizing the judicial process who possess only the half-truth, those for whom the concepts of judicial discipline, binding precedents, and inherent limitations of judicial discretion are elusive. This section of people, the half-truth knowledgeables, are a real challenge to the dispensation of justice through the rule of law. Social and digital media is nowadays primarily resorted to expressing personalized opinions more against the judges per se, rather than a constructive critical appraisal of their judgments. This is what is harming the judicial institution and lowering its dignity. The constitutional courts have always graciously accepted informed dissents and constructive criticisms, but their thresholds have always debarred the personalized agenda-driven attacks on the judges. This is where the digital and social media needs to be mandatorily regulated in the country to preserve the rule of law under our Constitution. Attacks attempted at judges for their judgments lead to a dangerous scenario wherein judges would have to pay greater attention to what the media thinks rather than what the law actually mandates. This puts the rule of law on the burner, ignoring the sanctity of respect for the courts. In the case of Sahara Private Limited versus SEBI, the Supreme Court devised the doctrine of postponement of publication. It is a precautionary measure where the media is not allowed to publish opinions about the sub judice matter till the hearings conclude. This doctrine of postponement is not to be read as a censorship or a prior restraint, but rather a safeguard against possible abuse. This can be one of the viable options, considering how the non-judicial factors are shaping the public opinion in this matter. A judicial verdict, right or wrong, is always by a court vested with powers under the Constitution of India as a court of record. The Supreme Court and the High Courts act as court of records by virtue of Articles 129 and 215 respectively of the Indian Constitution. The remedy of any judicial order or a judgment is clearly not available on digital or social media, but before the superior court of law in the judicial hierarchy. In India, which still cannot be classified as a completely mature and informed democracy, social digital media is employed frequently to politicize purely legal and constitutional issues. One of the cases in hand is the Ayodhya verdict, which was essentially a land and a title dispute bordering upon the title of a deity. However, by the time the final verdict came to be delivered, the issue attained political overtones. All those imputing intentions and motives to the Supreme Court for the Ayodhya verdict conveniently forgot that someday or the other, some judge had to decide the contentious civil dispute, which was indisputably one of the oldest litigations pending in the court of the country, running into more than 38,000 and odd pages. This is where the heart of any judicial proceedings before the constitutional court may disappear, and the judges deciding the dispute may get a bit shaken, which is antithetic to the rule of law. This is not healthy for the rule of law. Another issue which has always been a hot cake for the social and digital media is the punishments in cases of serious offenses. The immense power of these platforms is persistently resorted to for precipitating a perception of guilt or innocence of the accused even before the trial is over. This also sacrileges the rule, especially in high-profile matters where either the incident is hyped or the accused is a big man. Even before the trial is over, the society starts believing that the outcome of judicial proceedings ought to be nothing except conviction with the extreme penalty for the accused. Therefore, regulation of digital and social media, especially in the context of sensitive trials, which are sub judice, must be dwelled upon by the Parliament by introducing appropriate legislative and regulatory provisions in this regard. The question arises of how to resolve these concerns. A number of legislations, namely amendments to the Information Technology Act 2000, the Contempt of Courts Act 1971, are in place to tackle the problems of interference with the judicial processes, especially in sensitive sub judice matters. There have been several studies, reports, and recommendations, both nationally and internationally, suggesting ways and measures for handling the perpetual problem of media trial, especially through the digital and social media. One of the notable being the Madrid Principles of 1994, focusing on the interrelationship between digital social media and judicial independence. Madrid Principles essentially are an extension of the United Nations Principles on the Independence of the Judiciary from 1985, formulating rules and codifying guidelines delineating the boundaries of freedom of speech in the context of judicial independence. The preamble to the Madrid Conference, laying emphasis on the rule of law reads thus, I quote, freedom of the media, which is an integral part of freedom of expression, is essential in a democratic society governed by the rule of law. It is the responsibility of judges to recognize and give effect to freedom of the media by applying a basic presumption in their favor and by permitting only such restrictions on freedom of the media as are authorized by the International Covenant on the Civil and Political Rights. I unquote. The Madrid Principles have emphasized that it is the function and right of the digital media to collect and share the information with the public on the administration of justice, however, with appropriate checks and balances. Also important are the International Bar Association legal policy and research unit recommendations. The International Bar Association legal policy and research unit in 2011 carried out a global survey to consider the impact of online social networking platforms on the judicial system. 61 bar associations, including the Bar Council of India, from 47 jurisdictions across the globe responded. The report indicated that while the social media was a platform for discussion, wherein decisions of the courts may be criticized, judges should not succumb to its pressures. They must be loath to be influenced by it. Furthermore, this report minced no words in emphasizing that judges should not themselves resort to social media platforms by becoming privy to any such debates. This would do more harm than good for the rule of law, as judges never speak through their tongue, but only through their judgments. Ladies and gentlemen, at the end of the day, I may only say that judiciary cannot exist independent of the society, and the interaction is inevitable. But the rule of law is insurmountable. I am once again thankful to the distinguished guests for this honor. I also extend my thanks to the Ken Foundation. The students behind the foundation also deserve a huge applause for their determination and commitment to assist the foundation in its organizing of webinars like the current one, and also in other projects that the foundation is involved in. Thank you very much, Mr. Nidesh Gupta. Thank you very much, Mr. Siddharth Bhatnagar. It was a pleasure having you all on this symposium. Thank you very much, Professor Deep Nagar and Dr. Hope to see you all one day again on some debate. Thank you very much. Thank you so much.
Thank you so much, Lordship, for your golden words and for reminding us Justice Khanna's contribution to the jurisprudence of this country and how, as a judge, while upholding the rule of law, Justice Khanna paid great heed to fundamental rights of the citizens. Sir also rightly pointed the two basic roles of a judge, that is to uphold constitution and rule of law and to bridge the gap between law and society, which also reminds me of Justice Khanna, who is renowned for setting an example during the period that has been called the darkest hour of Indian democracy during the period of emergency. Lordship also highlighted that the rule of law shall prevail and overshadow the views of the public. The term view of the public is not synonymous with the people in general. Sir also spoke about trials by digital media at times crossing the Lakshman Rekha, and how attacks on the judges for their judgments lead to a dangerous scenario where judges would have to pay greater attention to what the media thinks rather than what the law mandates. And this reminds me of words of Justice James Madison in the case of Nia versus Minnesota, wherein he said that some degree of abuse is inseparable from proper use of everything. And in no instance is this truer than in that of the press. It has accordingly been decided by the practice of the states that it is better to leave a few of its noxious branches to their luxuriant growth than by pruning them away to injure the vigor of those yielding the proper fruits. Thank you once again, Lordship, for enlightening us. May I now request Mr. Nidesh Gupta, Senior Advocate, to please take us further in the session.
My Lord Justice Pardiwala, it's indeed a privilege to hear your Lordship today. My Lord rightly said that judges speak through their judgments and not through their tongue, but it's been a privilege to hear your Lordship's tongue today. Professor Ved Kumari, Vice Chancellor of the National Law University, Odisha, Professor S.K. Bhatnagar, Vice Chancellor of the Dr. Ram Manohar Lohia National Law University, my good friend Siddharth Bhatnagar, and other friends at Can Foundation and others in the audience. It is indeed a privilege to be before all of you today and to be associated as a panelist in a symposium which has the very name of my Lord Justice H.R. Khanna is indeed the greatest honor and privilege that a person from the legal field can enjoy. So it is indeed an honor to be participating in this symposium today. Justice H.R. Khanna, as we all know, was a bright shining light at a time of pitch darkness. And to be associated with the symposium, which is in his name, is indeed a great honor and a great privilege. In the famous epic Mahabharata, there is a dialogue between Bhishma Pitama and where Bhishma Pitama and Yudhishthira are in conversation. And Yudhishthira asks Bhishma Pitama that what is this entity called Raja? How come he has so much importance, so much prominence, and so much power? And Bhishma Pitama responded by saying that at the time of Satyug, he said, Never Rajyam na Raja Seet, na Dando na cha Dandikaha, Dharmaneva Praja Sarvaha, Rakshantiksam Parasparam. He said in Satyug, there was neither any Rajyam na Raja, there was neither any king nor kingdom. Na Dando na cha Dandikaha, there was neither any punishment nor anyone to mete out punishment. Dharmana eva prajah sarva rakshantiksam parisparam. So it was dharma which protected one from the other and maintained harmony amongst all sections of society. Unfortunately, this experience of Satyug, where all people lived in love, respect, and understanding, with no external control, did not last very long. And despite rise, and as has been said in all scriptures, in fact, the Srimad Bhagavad, the Mahabharata, the Yoga Vashisht mention this famous shloka that as desires rise, they compel action, and desires are never quenched, and that leads to more and more action, and then vested interests come into play. So as more and more desires rise, more and more actions take place, then what is described as Raj Shakti or Dand Shakti comes into play, and that is where the rule of law has such a major role to play in our society, to bring justice and to apply it uniformly across all sections of society. We find in the recent pandemic, for instance, we find that there are sections of people who are opposed to masking, who are opposed to social distancing, to vaccination. And there are governments which feel to the contrary. If we don't have a rule of law, again, the system becomes impossible to work. At the same time, we have rules which are based sometimes on a misconception. For example, if we see the caste system in India, and I'm aware of my Lord's views on that, but I would go back a little in time. The caste system as enunciated in our scriptures was based on the three gunas, satoguna, rajogun, tamogun. Sattvic, that which is pure and vibrant. So a Brahmin was one who was very vibrant, pure, dedicated to other people. A Kshatriya had more Rajogun, that is, he was more action-oriented. So a Kshatriya had a more action-oriented life, but his activity was dedicated to the welfare of the people of the country. So it was tempered by Satogun. A Vaishya had a lot of Rajogun, a lot of activity, but that was tempered by his selfish needs, by his desire for personal benefit. And then a Shudra was one who was indolent, who was sleeping, who was drugged out, and not engaging in any activity. This was the basis of the caste system. And yet we have a plethora of laws which completely twist because of wrong public understanding of what the law really stood for. And we have the mess of the entire caste system and all that we see in the world, in our country today. But one of the problems which the principle of vox populi and its usage in shaping judicial verdicts is that public opinion is invariably determined by considerations which are extraneous to the judicial process. Public opinion is determined by political, religious sentiments, by traditions, by usual belief patterns, gender stereotypes, as Professor Ved Kumari said so passionately at the start of our discussion, as opposed to legal and constitutional principles. Public opinion can be easily influenced by the media, as his lordship just mentioned, and the narrative which the media chooses to adopt based on factors which are completely extraneous to judicial considerations. And all of these factors then shape public opinion, as the general public is conditioned to think about particular situations in a particular manner, being constantly fed that narrative by the media. Then the general public are at the most time ignorant of and inexperienced with regard to intricacies of law. They are not trained to sift through evidence, to consider with a judicial mind, and have disregard to anything which is extrajudicial. Any incorporation of public opinion in the judicial process is therefore fraught with the inherent risk of ignoring the intricacies, the purpose, the purport of law, and incorporation of extrajudicial considerations in the legal process. This issue, as my Lord Justice Padiwala put out so well, is very evident from the failure of the jury system in our country. The jury system was based on the idea that the jury offers a voice of the people in the dispensation of justice and would be more representative of the general public mind. The primary advantage and justification for the jury system was the association of the general public and therefore public opinion in the administration of justice. But the jury system failed completely, and all references to juries from the statute was completely removed as a part of the overall of the Code of Criminal Procedure. The statutory foundation of the right to trial by jury, which was in the 1898 Act, the CRPC, the code in sections 267, 268, 269, was completely done away with when the overall was done in 1973 of the code. It was limited to some presidency towns, etc., and then it was finally discontinued. In the first Attorney General of India and the first chairman of the Law Commission of India, in the 14th report, the final report submitted by the Law Commission to the then Law Minister, also noted, and what is relevant for the present discussion, are the reasons for which the jury system completely failed. The Law Commission observed that the jury system had failed in the aspect of delivery of justice itself. The Law Commission noted a statement made by the then acting Chief Justice of the Bihar High Court, where he said, and I quote, "The unsatisfactory manner in which the system is working is notorious, and all those connected with the administration of criminal justice in the country must know of numerous cases of miscarriage of justice." The Law Commission then noted similar concerns voiced by multiple bodies regarding the working of the jury system. In fact, my Lord quoted from Mahatma Gandhi. They also went on to quote Mahatma Gandhi, who wrote in Young India then, and said, where Mahatma Gandhi said, and I quote, "I have known juries finding prisoners guilty in the face of no evidence, and even judges summing up to the contrary. We must not slavishly copy all that is English. In matters where absolute impartiality, calmness, and ability to sift evidence and understand human nature are required, we may not replace trained judges by untrained men brought together by chance." And I end of quote. So the concerns voiced by the Law Commission, which led to the Law Commission recommending the abolition of jury trials, are bound to occur if general public is involved in the judicial process, or if views of the general public are made a part of this general, of the process of law. We must not forget, for example, what the great Sufi saint Jalaluddin Rumi said. He once said, the whole world has taken a wrong direction. The whole world has taken a wrong direction. Now, if you follow public opinion in deciding which way justice must go, then inherently there is this danger which is fraught with that. Then similarly, the Nanavati trial, which was extensively covered by the media, the Blitz portrayed Nanavati as an upright naval officer, Ahuja as a liquor-drinking playboy with Sylvia, a remorseful wife. And the portrayal of characters involved in the trial led to a great deal of sympathy and huge public opinion in favor of Nanavati, leading to loud cheers, I read, in the courtroom when the verdict of not guilty was pronounced by the jury, which verdict was found to be perverse and later overturned by superior courts. The said public opinion in favor of not guilty, in favor of Nanavati, was possibly the ultimate verdict of the jury, which was driven completely by media portrayal of the central characters involved in the alleged crime and based on entirely extrajudicial considerations. Before I come to a more recent example of what happened with Johnny Depp and Amber Heard, which I'll touch a little later, there is a very interesting amalgamation of the two, which is noticed by Lord Reed in the Attorney General versus Times newspapers case. So I noticed the facts from his judgment and I read them. In 1958, Distillers Company, and here Justice Lord Reed finds a method, a very ingenious and innovative method to use public opinion to bring justice. And I therefore share this with you. In 1958, Distillers Company began to sell in this country a sedative which contained a drug, thalidomide. This product was available on prescription and was consumed by many pregnant women. Soon there were cases of babies being born with terrible deformities. It took a little time to prove that these deformities were caused by the action of thalidomide in the unborn children. As soon as this was raised, distillers withdrew their product in 1961. The question arose whether distillers were legally liable to pay damages in respect of these deformed children. 70 actions were initiated. An out-of-court settlement was reached by which the distillers agreed to pay each claimant 40% of the damages which he or she would recover if successful in establishing liability. Then the matter again went to court. A leave was granted to serve writs in July of 1968. And then I come back and read from the judgment. Lord Reed then says that the editor of the Sunday Times took a keen interest in the matter. He collected a great deal of material, and on 24th September 1972, the newspaper published a long and powerful article. Then Lord Reed quotes one paragraph from that article published in the Sunday Times, and I quote that. Thirdly, the thalidomide children shame distillers. It is appreciated that distillers have always denied negligence, and that if the case were pursued, the children might end up with nothing. It is appreciated that distillers' lawyers have a professional duty to secure the best terms for their clients. But at the end of the day, what is to be paid in settlement is the decision of distillers, and they should offer much, much more to every one of the thalidomide victims. It may be argued that distillers have a duty to their shareholders, and that having taken account of skilled legal advice, the terms are just. But the law is not always the same as justice. There are times when to insist on the letter of law is exposed to criticism and infringement of another's legal rights. The figure in the proposed settlement of 3.25 million spread over 10 years. This does not shine as a beacon against pre-tax profits last year of 64.8 million and company assets of 421 million. Without in any way surrendering on negligence, distillers could and should think again. End of quote. So the issue was whether distillers were in contempt in having written so, whether the Sunday Times was in contempt on having written so on a matter which was sub judice before court. So when this matter traveled before his lordship, then he quotes from Justice Buckley in Mackenzie and says, Justice Reed refers to Justice Buckley and quotes from Justice Buckley where it is said, it is contempt of this court for any newspaper to comment on pending legal proceedings in any way which is likely to prejudice the fair trial of the action. So having noted that, then Justice Reed opined by saying, and I quote again, I think that this is much too widely stated. It is true that there is some authority for it, but it does not at the least follow from the observations of Lord Hardwicke, and it does not seem to me to be in accord with sound public policy. Now at this stage, Lord Reed brings in Merchant of Venice and quotes from Shakespeare. And we all know that here was a case where Antonio had taken so much money, he had failed to pay. His good friend Bassanio was willing to pay twice over. And then Shylock said, no, I have a decree in my favor, I'm entitled to my pound of flesh. And then Portia comes in and says that tarry a little, you may have your pound of flesh, but in the taking, if you were to shed one drop of Christian blood, then all your lands will be confiscated under the laws of Venice, etc. So he was not willing to take his money back, double the money back, but wanted the pound of flesh. Now Lord Reed says here, why would it be contrary to public policy to seek by fair comment to dissuade Shylock from proceeding with his action? Surely it could not be wrong for the officious bystander to draw his attention to the risk that if he goes on, decent people will cease to trade with him. Or suppose that his best customer ceased to trade with him when he heard of his lawsuit. That could not be contempt of court. Would it become contempt if, when asked by Shylock why he was sending no more business his way, he told him the reason? Nothing would be more likely to influence Shylock to discontinue his action. It might become widely known that such pressure was being brought to bear. Would that make any difference? And though widely known, must the local press keep silent about it? They must general statement of law. So Lord Reed then suggested a very innovative method, namely that let public opinion be used to dissuade people from dealing with such people, and came out with this rather innovative and it may appear a little peculiar and sometimes may be difficult to apply, but a very interesting method of drawing public opinion to establish justice and bring rule of law into play. Now, coming back, we all know about this recent trial. It was so widely reported, the Amber Heard Johnny Depp trial. There was a public verdict in favor of Johnny Depp, which unfortunately was pronounced much earlier to the jury verdict. Amber Heard's depositions were converted into mocking memes and circulated by the millions on public platforms. I was very surprised and I thought it was a typographical error, but I found that the hashtag Justice for Johnny Depp received over 20 billion views. Just the number, how many times people went back to that. And I actually thought maybe there's a typo in that, but I noticed that's common across various platforms. So the hashtag received 20 billion views with an unsequestered jury having all access to all the ridicule that Amber Heard was being subjected to. I remember during the O.J. Simpson trial, the jurors were completely isolated from public opinion and were kept completely shorn of all public opinion for 265 days, which is the longest period a jury has been sequestered, which itself shows the importance of keeping public opinion out of the way. This public opinion of guilty in favor of Amber Heard, and it was possibly the ultimate verdict of the jury, again, which was driven by the portrayal of the central characters involved, namely Amber Heard portrayed as a crazy, possessive, abusive girlfriend, Johnny Depp, an imperfect but a very supportive boyfriend. Johnny Depp's imperfections seem to enhance his credibility and see him as flawed but human, vulnerable, while Amber Heard's imperfections used to undermine her and to view her as completely monstrous. Larger issue with the public opinion in favor of Johnny Depp, driven by the narrative, driven by streaming channels, and Johnny Depp fans in particular, was that it would ignore evidence against Johnny Depp where messages and other evidence were there where he calls himself a monster, apologizes to Amber Heard, videos where he's slamming cabinets, photographs, etc. Now, this selective consideration of evidence by the public, all the media, the streaming channels, Johnny Depp fans, all based on extrajudicial considerations, ultimately perfectly encapsulates the risk of vox populi being given being adhered to in preference to the rule of law. And what is perhaps most interesting in this trial is that Johnny Depp had filed a similar lawsuit against The Sun, a British tabloid, over an article in which The Sun had directly named him, unlike Amber Heard, who never mentioned his name in the Washington Post. He very smartly never implemented Washington Post in the array of parties in the US court. But the British tabloid specifically called him a wife beater in the article. It was a trial before a judge as opposed to a trial before a jury, which was in the United States. The British court, after considering the entire evidence, found that Johnny Depp had physically abused Amber Heard on at least 12 occasions. This, despite the burden on Johnny Depp being far lower in the UK trial and there being stronger laws in the US regarding protection of free speech. In both instances, the character of Amber Heard was attacked, with the difference being that the said tactic was repelled by the judge in the UK, whereas it was allowed by the jury in the United States. The judge in the UK focused on the singular issue at hand, namely whether Johnny Depp committed domestic abuse or not, unlike the jury in the United States. And that really summarizes why the danger of allowing the dangers manifest in a jury trial or allowing public opinion to play a larger role. I would also like to quote something which was said more than 250 years ago, and which is still so profound and really makes your hair stand on end. This was said by Lord Mansfield more than 250 years ago in R.B. Wilkes in 1770. And this is what he said, and I quote. And he was subjected to getting many letters, etc., which I'm sure all honorable judges are accustomed to. So he says, and I quote, "I pass over many anonymous letters I have received. Those in print are public, and some of them have been brought judicially before the court. Whoever the writers are, they take the wrong way. I will do my duty unawed. What am I to fear? The mendax infamia from the press, which daily coins false facts and false motives. The lies of calumny carry haut tenor to me. I trust that my temper of mind and the color and conduct of my life have given me a suit of armor against these arrows. If during this king's reign I have ever supported his government and assisted his measures, then I have done it without any other reward other than the consciousness of doing what I thought right. If I have ever opposed the king, I have done it upon points themselves, without mixing in party or faction and without my collateral views. I honor the king and respect the people, but many things acquired by the public of either are in my account objects not worth ambition. I wish popularity, but it is the popularity which follows, not the popularity which is run after." And such powerful words. It's so wonderful to read something like this. It is that popularity which sooner or later never fails to do justice to the pursuit of noble ends by noble means. I will not do that which my conscience tells me is wrong. Upon this occasion, to gain the huzzas of thousands or the daily praise of all newspapers which come from the press, I will not avoid doing what I think is right, though it should draw on me the whole artillery of libel, all that falsehood and malice can invent, or the credulity of the educed populace can swallow. End of quote. And really powerful words said more than 250 years ago, and so relevant and so true even today. Judicial determination cannot, therefore, I say, succumb to public opinion and must be based strictly on the rule of law. It must be based strictly on constitutional legal principles, as my Lord has so wonderfully and so articulately said. While judges cannot exist in silos, the ultimate responsibility of the judge is indeed to uphold the rule of law. Public opinion perhaps can be used as a mechanism to enable speedier justice, as we noticed in the cases of Nirbhaya and Kiran Negi. The comparative public outrage in the two cases, while Kiran Negi was raped and murdered, perhaps even more brutally than Nirbhaya, but the media campaign and the collective outrage was not as wide as in the case of Nirbhaya. Consequently, justice for Kiran Negi and for other women and for other victims of equally brutal crimes is often far more delayed. So perhaps that is where public opinion can play a larger role. I also noticed that the Supreme Court has also said so. Justice Sinha in Santosh Kumar said, public opinion may run counter to the rule of law and constitutionalism. More recently, Justice Madan Lokur in M.A. Antony said, and I quote, where he quoted from Bachchan Singh's case, where it is said, incidentally, the rejection by the people of the approach adopted by the two learned judges in Farman furnishes proof of the fact that judicial opinion does not necessarily reflect the moral attitudes of the people. At the same time, it is a reminder that judges should not take upon themselves the responsibility of becoming oracles or spokesmen of public opinion. Not being representatives of the people, it is often better, as a matter of judicial restraint, to leave the function of assessing public opinion to the chosen representatives of the people in the concerned legislature. End of quote. As my Lord put it so wonderfully, in my view, ultimately, it boils down to the mettle of the person occupying the seat. We may have the finest laws in place, but at the end, it always depends on the person holding the office. Is he swayed by public opinion, or is he true to his oath? And perhaps the answer lies in what is said 21 times in the Mahabharata, and is incidentally the motto of the Supreme Court of India, our Honorable Court. Yatho dharma, tato jaya. Where there is dharma, where there is righteousness, there is undoubtedly based in our country completely on what is righteous and what is dharma. It has been a greatest pleasure to share this platform with you, my Lord Justice Pardiwala. We have, in the last few days, already noticed how although you're new to this Honorable Court, but we have seen your judgments, and it's a great honor to share this platform with you and to see how fearlessly you articulate your views here and also in court. It's indeed a pleasure, sir, to be with you here and to also be here with Professor Bhatnagar and my friends in Can Foundation, and to share these views with others in the audience. Thank you so much for this opportunity to be part of this event. Thank you.
Thank you, sir, for enlightening us. Justice Khanna was indeed a bright, shining light in the darkest times. Nidesh sir mentioned when more and more desire increases, then Shakti comes in play, the rule of law comes in play. And without rule of law, no system can work. Sir took us through Mahabharata and highlighted the importance of Dharma during his address. And also an important point that was made, that if public is made part of the process of decision-making, then it will be dangerous. Reference to Johnny Depp, Amber Heard case, and how in a case, jury was kept away from public opinion to show that public opinion should not determine the decision-making. And the rule of law alone should be the basis of decision-making. Thank you once again, sir, for your words of wisdom and golden words. May I now request Mr. Siddharth Bhatnagar, Senior Advocate, to address the participants.
Honorable Mr. Justice Pardiwala, Mr. Nidesh Gupta, Professor Ved Kumari, Professor Bhatnagar, Mr. Tariq Khan, Mr. Siddharth Gupta, Shriram, Abhikalp, office bearers and members of the Can Foundation, my dear friends. It is an honor for me to be invited to participate in this symposium, the theme for which was very close to the heart of Justice Khanna, in whose memory we are meeting today. Not least because many of his judgments touched upon it or were based on these, but he continued to speak and write about these aspects even on demitting office. It was so dear to him. My Lord Justice Pardiwala, in his illuminating keynote address, and Mr. Gupta in his presentation have already dealt with the theme most comprehensively, for which we are truly grateful. So what I propose to do, therefore, is to place before you some thoughts of mine for your consideration on these two competing, conflicting viewpoints. As you know, and as my Lord pointed out also, Vox Populi commends or tells you about the voice of the people in a sense, while the rule of law, in essence, is summed up as not giving public authorities the right to exercise authority over citizens other than what is provided by the law. That's one. Second, a minimum basic legal rights to citizens. And third, access to an independent judiciary to vindicate these rights and to enforce the limits of state power. It is this third aspect, the role of the independent judiciary, that I would like to touch upon today, because it applies to the other two aspects as well. An example of chaos and brute force being the exact opposite of the rule of law can be illustrated by an example actually from Greek mythology, when, as you know, Agamemnon sacrificed his daughter to please the gods before going into battle with Troy. His wife murdered him to avenge the deed, and she in turn was murdered by her son. This is when Athena, the goddess of wisdom, created a court to impose a solution. And that court actually mirrors principles, very interestingly, of modern legal thought, providing procedural and substantive justice. So that is Greek mythology. So may I start by placing my point, which basically is this. Our constitution, which is the fundamental document of governance, gives more leeway than most democratic constitutions to elect representatives in the manner of making laws and particularly amending the constitution itself. Elected representatives, in a sense, represent the majority of the people, but the emphasis on the constitution is on the citizen, not the state. The constitution conceives of the state existing for the citizen and not for the citizen existing for the state. That is why I submit before you that the protection of rights through the rule of law must not only be balanced, but take precedence over any right asserted by the state through the medium of majority opinion. To put it a bit differently, if I may put it slightly differently, it is absolutely possible to have an absolute democracy where the state is permitted to expand and enforce its power to threaten the liberty of individuals themselves. On the contrary, we can never have an excess of the rule of law. So this is the point that I'm just trying to elucidate before you today. And incidentally, we are in the 73rd year of our constitution. A study was done by the University of Chicago on the lifespan of constitutions of independent states since 1789, the year of the French Revolution. And it was found that the mean lifespan across the world for constitutions was 17 years, 17 years. In fact, Sir Ivor Jennings, the great constitutional expert, in 1951 had predicted doom for our constitution. He said it would not endure. What in fact did not endure was the constitution of Ceylon, now Sri Lanka, which was drafted by him in 1960. That lasted only for 6 years. And the point is that our constitution has endured sometimes difficult times is solely on account of the insisted adherence to the rule of law by our citizens and, more importantly, our superior courts. So when we speak of Vox Populi, we could begin with one of the conundrums of modern democracy. The state itself is ultimately in the hands of electoral majorities. And these electoral majorities themselves are capable of exercising oppressive power, which could undermine democracy itself. The other side of the coin is that fundamentally citizens feel obliged to obey the state because of the legitimacy of the political order on which it is based, and also, of course, on the basis of the coercive power of the state. In this respect, all modern democracies act through elected legislators, not only as representatives of the citizens, but also for the reason given by James Madison. He was cited the chief draftsperson of the US Constitution, and he felt that a chosen body of citizens was less likely to sacrifice the true interests of the country to short-term considerations or sectional interests. That is the vision in the Federalist Papers. Madison was part of one of them. Equally, legitimacy of state action in a democracy depends on general acceptance of the decision-making processes and not only the decisions themselves. That is to say, the method of making decisions. And as a necessary conjunct, the role of the judiciary in curbing and striking down illegal and irrational decision-making. Democracies operate on the implicit basis that though the majority has authorized policies and decisions that the minority may reject, but those differences are transcended by the common acceptance of the legitimacy of the decision-making process and the remedies against them before an independent judiciary. This is what Mr. Nani Palkhiwala said of the dangers of blindly following a majority rule. Very strong word, but may I just quote them for you? This is what he said, I quote, "It is easier to throw off a foreign tyranny than the tyranny of our own elected representatives. And a law does not cease to be tyrannical only because it is passed by the elected representatives of the people. Therefore, price of being a citizen of a democracy is eternal vigilance." This is Mr. Nani Palkhiwala's views, which he expressed in the context of the 24th Amendment to the Constitution, in fact. Now, when our great Constitution was framed, we did not adopt the strict Montesquieuan doctrine of separation of powers, but we rather went for the Westminster model, where the executive also has a key role in framing and passing legislation through Parliament. So essentially, we broadly follow what Hamilton wrote in the Federalist Papers, that the legislature makes laws, holds the purse, executive executes the laws, but it is the judiciary that holds judgment. And our Constituent Assembly that framed the Constitution was formed under an act of the British Parliament, namely the Indian Independence Act of 1947. The members of the Assembly were elected by the elected representatives of the provincial legislatures, and those in turn were elected by an electorate, not on the basis of universal adult franchise, but by a vastly limited electorate based on certain identified criteria, such as being a graduate, taxpayers, etc. Therefore, the Constituent Assembly was always careful enough in its realization that it was elected by less than the third of the then adult population. That and the limited time frame available to carry out that exercise meant that they were very careful to frame a document that provided the representatives elected by the majority relatively easier opportunities to amend the Constitution itself, as Parliament would be elected from a full adult franchise of people over 21 years. Now it is 18 years. So that they were very conscious of that. And among the constitutions of other countries that they considered, that our Constituent Assembly considered for this purpose, were the American Constitution of 1789, Commonwealth of Australia Act 1900, and the Irish Constitution of 1937. Each of these constitutions had advisedly made amendments very, very difficult, extremely difficult. For instance, under Article 5 of the US Constitution, an amendment to the Constitution requires a 2/3 majority in both houses of Congress, as well as a ratification by 3/4 of the states. Some subjects are outside the pale of amendment completely. Consequently, in about 230 years, the House of Representatives sent 33 amendments to the states, of which 27 were ratified. So the US Constitution has been amended only 27 times. Ours has already been amended over 100 times. 105th, I think, was the last amendment. In Australia, the amendment to the Constitution requires a referendum by a triple majority. That is, a nationwide majority, as well as a majority of voters in a majority of states. So in Australia, they've had 44 referendums in the last 122 years, and only 8 amendments have been passed, the last of which was in 1977, 40 years ago. Irish Constitution was very interesting. They have an amendment by referendum, but for the first 8-year period, of the Constitution, it was said that an amendment could be done by a simple majority. This was to redress any difficulties in the working of the Constitution. And Ireland's Constitution has now been amended about 32 times. So with these models before it, the Constituent Assembly still chose to provide a relatively easier method of amendment in Article 368 of our Constitution, which is 2/3 of the members of a House present and voting, and a majority of the total membership of the House. For certain other amendments, there's a ratification of the majority of states required under the proviso to 368. So it was in the mind of the Constituent Assembly to permit directly elected Parliament to carry out amendments and to meet the felt need of the times more easily than the other constitutions which they considered. The fact that elected Parliament would represent majority rule is a basic principle of democracy, but this only authorizes actions of the state. It does not make them legitimate. This is why democracies must have methods, and we have, of limiting or diluting the powers of majorities through law and the judicial processes. The law lays its emphasis on individual rights, and an independent judiciary must necessarily be accountable to the electorate for their decisions. Must necessarily not be accountable to the electorate for the decisions. An independent judiciary is not accountable. Second, the judicial process is characterized by abstract reasoning. Judges do not decide cases in accordance with public opinion. In fact, our flexible living constitution permits judges to fill gaps by applying the rule of law. Judges have always made law because to decide disputes between parties, they have to also fill gaps, supply answers that cannot be found in existing sources. Law which has grown through earlier decisions remains the major source, stare decisis. Judges have traditionally done so within the existing framework of legal principle and without trespassing on the functions of executive and parliament. But as I placed before you, our Supreme Court has been able to subject decision-making to strict and rigorous judicial scrutiny. Therefore, any thinking that elected representatives are entitled to ignore or abrogate constitutional rights as an expression of the democratic will of the people is the foundation of a totalitarian state. In the very first year of our constitution, in Gopalan's case, our Supreme Court cited with approval the United States Supreme Court that a government which does not recognize inalienable human freedoms and which holds, and may I just quote this for you, the lives, the liberty, and the property of its citizens subject at all times to the absolute disposition and unlimited control of even the most democratic depository of power is after all but a despotism. It is true, it is a despotism of the many, of the majority if you choose to call it, but it is nonetheless a despotism. Our courts apply the rule of law every day, and any instances in this regard are beyond enumeration. But when we look at the laws made by parliament or state legislatures, there are a number of instances where these laws are struck down, partially or wholly, for either violating federal distribution of powers, that is to say legislative competence, or by contravening fundamental rights or any other provision of the Constitution, to which is added manifest arbitrariness in legislation. That's a recent addition. Merely because laws have the imprimatur of parliament or state legislature as elected bodies has never protected them from scrutiny. As far as constitutional amendments are concerned, because I touched upon that a bit, there are separate genus altogether because the interpretation of the Constitution involves principles different from ordinary principles of interpretation, as first laid down by Chief Justice Marshall in the famous 1819 case of McCulloch and Maryland, consistently followed by a Supreme Court. Even when we look at amendments to the Constitution themselves, some of which had the ratification by legislatures of not less than half the states, they were not safe from judicial scrutiny at all. Before I mention some examples to buttress my point, I would submit before you that the greatest contribution of the Supreme Court has been to preserve the Constitution and as a concomitant, the rights that flow from it. the preservation of constitutional rights was at the helm since the first year of our constitution itself, and later on led to the development of the basic structure axiom or principle that the basic structure of the constitution cannot be touched or tampered, first mooted way back in 1965 by Justice Modholkar in Sajjan Singh's case. Thereafter, and I'll just take you through a few examples. Golaknath, 1967, Supreme Court was deciding whether the power of amendment lays solely within Article 368 or in a residuary article, or whether it was a sui generis power consistent with a changeable constitution, held that fundamental rights could not be amended. Then came the famous Keshavananda of 1973, where the Supreme Court introduced into our constitutional law the principle that Parliament cannot, by an amendment of the Constitution, alter its basic structure. There were 4 amendments that the court was considering: the 24th, 25th, 26th, and 29th amendments. The 24th amendment had sought to supersede Golaknath by enacting that Article 13(2) shall not apply to constitutional amendments. So it aimed at empowering Parliament to take away or abridge all or any of the fundamental rights, and to confer generally on Parliament an unfettered power to alter the whole or any part of the Constitution. The 25th Amendment had inserted Article 31C to give effect to directive principles contained in certain articles 39B and 39C. And 31C also contained a stipulation that no law containing a declaration that it is for giving effect to such policy should be called into question in any court on the ground that it does not give effect to such a policy. This part of 31C was declared invalid. Incidentally, it was the judgment of Mr. Justice Khanna in Keshavananda, which was described by Mr. Nani Palkiwala in an SCC article as having become the law of the land over the other 12 judges, because he had held that the power of amendment was limited and did not enable Parliament to alter the basic structure of the Constitution. And further, that Article 31(c) was held to be valid on the ground that it did not alter basic structure. But the latter part of 31C was invalid. So in essence, what Keshavananda or what the Supreme Court did in Keshavananda was preventing a coach and horses being run over the fundamental rights chapter, the most significant part of our Constitution, in fact. Post Keshavananda, if you see 1975, Indira Gandhi's case, challenge was to an article which provided that the election of the Prime Minister and Speaker could not be void or ever become void on any ground, notwithstanding any order made by a court. This was struck down on the ground of being violative of basic structure and the rule of law, because the Prime Minister and the Speaker could not be placed on a different footing from anyone else. Thereafter, 1980, Minerva Mills, another constitution bench, where the challenge was to the inclusion of 2 articles in 368 by the 42nd Amendment, which had provided that no constitutional amendment could be called into question in any court. Second, there was to be no limitation on the power of Parliament to amend any provision of the Constitution. This was again struck down for violation of basic structure. Then we have cases such as Sabamurthy, L. Chandra Kumar, where Articles 226, 227, and 32 were sought to be excluded. The Supreme Court said not possible, basic structure. Kihoto Holohan, where the jurisdiction of the court, which was barred by a paragraph in the 10th schedule, was struck down because judicial review is part of the basic structure. And then lately, the 99th Amendment of the Constitution, by which the NJAC, the 99th Amendment was declared unconstitutional, and the NJAC was declared unconstitutional as being violative of basic structure, because that amendment did not provide adequate representation to the judiciary as to prevent the primacy of the judiciary in the manner of selection of judges to the higher judiciary. The entire amendment was set aside. And only last year, the Supreme Court struck down certain parts of the 97th Amendment, which had included Part 9B to our Constitution, which is cooperative societies, because they had not taken ratification of more than half of the states. Again, if we just look a little forward, Shayara Bano 2016, the court holds that any legislation, plenary or subordinate, can be challenged on the ground of arbitrariness. So that's a departure from the earlier view of the Supreme Court itself. And the court has also resurrected and created rights taken away by earlier judgments. My Lord Justice Pardiwala referred to under the Section 377 law. Another is Puttaswamy, which recognizes privacy as a core fundamental right. So these limited examples that I've provided are only to illustrate how elected representatives have made attempts to exclude judicial review, to abridge or abrogate fundamental rights, to place individuals above the law, and to make laws without legislative competence. In all these cases, the Supreme Court has had to step in to preserve the rule of law. And if I may now summarize my submissions before you in 4 or 5 points. The first, the case for a balance to vox populi by the rule of law is simple. Mere fact that the nation is governed by elected representatives of people is no guarantee that constitutional rights will be respected or upheld. Some of the worst tyrannies in history and even today can be found in countries where the legislature consists of elected representatives of the people. It is those elected legislatures who have either abolished or have acquiesced in the abolition of civil liberties in rights in totalitarian states. In fact, the abridgment of fundamental rights has always been perpetrated in the name of public welfare. We only need to look at the judgments of our Supreme Court, but also those in United States, Australia, and Canada, highly developed democracies, to see that it is the people's representatives who have tried to violate freedom of the press. Second, if I may just turn once again to a quotation of Mr. Palkhiwala on majority rule. He said that the circumstance that an action is taken with the consent of the majority does not carry an assurance that the action will be wise or just. The majority verdict resulted in Christ being crucified and Socrates being ordered to drink hemlock. Even sincerity of purpose avails nothing, since the important point is not that you act according to your lights, but that your lights must be luminous. Third, our constitution provides for a just balance between the legislature, the executive, and the judiciary. The superior courts have the inescapable duty of guarding the fundamental rights and preventing infringements to the rule of law by any authority within the state. The fact that such transgression is by elected representative on behalf of the majority is irrelevant. Fourthly, it is the courts that maintain the fundamental equilibriums of our society and ensure that constitutional mandates are respected, whether it is protecting the constitution on the principle of basic structure, permitting challenge to legislation, it can all be traced to the adherence of the rule of law. Fifthly and lastly, I would like to conclude by quoting from a speech which was delivered by Mr. Justice Khanna in 1977 after he demitted office. And this is what he said: the content of the rule of law varies, but everywhere it is associated with the liberty of the individual. The question of reconciling individual rights with the requirements of public interest has always posed a vexed problem. Such reconciling and harmonizing can be attained by adherence to the rule of law and by the existence of independent courts, which can hold the balance between the citizen and the state and compel both to conform to law and order. So these are some of the thoughts I wanted to share with you today. I'm very grateful to my Lord, Nidesh, and all the other participants of this symposium. Thank you very much.
Thank you, sir, for highlighting the importance of the rule of law and the role of judiciary in upholding the same. Our constitution has endured difficult times only because of adherence to the rule of law. In fact, judges fill the gaps by relying on the rule of law in cases where sources are not adequate. Sir also discussed the importance of independence of judiciary. And the best example is, of course, Justice Khanna, who proved to be a valiant soul and an embodiment of independence. Thank you once again, sir, for your words. May I now request Mr. Sriram Prakad to deliver the vote of thanks.
Thank you, Tariq. Honorable Justice Pardiwala, Nidesh Gupta, sir, Siddharth Bhatnagar, sir, Professor Ved Kumari, ma'am. Considering the level of erudition, eloquence, and the sheer effort put in by our panelists, mere formal deliverance of vote of thanks would be exceedingly insufficient. However, I take upon this opportunity on behalf of the audience on behalf of Khan Foundation, and on behalf of posterities of audiences who would be accessing these valuable speeches through our YouTube platform, just to say thank you. Thanking Abhigalp and Tariq for bridging the session with their role as moderators. On behalf of Khan Foundation, I thank our esteemed effort partners, Phoenix Legal, Hemant Sahai and Associates, ELP partners, Economic Law Practices, our knowledge partners, Eastern Book Company, SCC Online, Bar and Bench, and last but not the least, the student volunteers without whose toil, not only this symposium, but no venture of Khan Foundation would be near to complete. I take this opportunity once again to thank our patrons, our mentors, our donors for having been with us all throughout. Thanking everyone once again. Thank you.